Amongst those will be the issue that relates to Glencore. But let me say that before we start the meeting, my first issue is that when I was going to start this meeting, I just got a courtesy call. I'm not sure whether the department also has been made aware that there is a process that seeks to deal with Section 189, which is the at Sibanye, Stillwater. Obviously, Section 189 in the main deals with the issue of what I would call the rationalization of work. In the main, it talks to what will lead or could lead to job losses. And I was informed that this morning there is that discussion between the labor and the management of Sibanye Stillwater. And I hope we will get a proper briefing and a formal communique on the matter with regards to Sibanye. Obviously, it's one of the sad moments. I always say it's like somebody gets buried alive if it leads to the ultimate issue of rationalization or job losses. The second part, some of the issues is that I'm not sure whether I'll be using a correct word, is the disappointment. And I know that the president today is convening the GBV summit. It is unfortunate also to report to the committee that we're currently receiving information that all the charges that relate to sexual assault, rape, have been withdrawn on the suspect with regards to the Krugersdorp case. And this does not send a good message in terms of clamping down on issues of gender-based violence, in particular sexual assault incidences. And I hope that this is just a temporal arrangement or a temporal retreat that will come back with the actual facts. Otherwise, the message that is being sent is that the state, in particular, the criminal justice system and police, to be specific, might be just rushing on issues in order to do what I would call a publicity exercise. So I think that is one part that has been a setback, if one can use the correct word. That this is a setback to us. In terms of addressing the crisis of social violence in the industry. But before going to any other thing, can you table the agenda, Ari or Ayanda?
I'll get it now, Chair.
Yes, the item, as I said, will get a briefing from the DMRE on the issue of Glencore, and then we will then deal with the correspondences. I must say one of the worrying factors is that we are beginning, I'm not sure whether it's a good thing or what, we're beginning to receive more like a booklet of correspondences. But I'm sure when we arrive on those issues, honorable members will be able to tackle such matters. Without wasting any time, can I then give over to the minister to brief the committee on the matter that relates to Glencore activities in South Africa? Honorable Minister, the platform is yours.
Thank you very much, Honorable Chairperson, Honorable Lusipo, Honorable Whip of the Committee, Honorable Mika, Honorable Members of the Committee, Team TMRE, led by the DM, Nobu Tlenkabane. Let me just introduce it and allow Teko Mbele and Sitoma Kubela to take us through. The first comment I want to make is that we are going to be chasing a number of things. Multinational companies operate in various countries. Now, if a multinational company commits, let's say, a crime in another country, we have to investigate it here. We are going to run until we're tired because Glencore, from where we are seated, we have not raised any issue about Glencore or any deviation of Glencore from working within the parameters of law. And if they do, and there is a case to answer, we believe that it is the responsibility of the law agencies to pursue that case. Now, as a department, we're not going to give you any case that relates to cases because that's not our competence. We're not having the capability to do so. But we'll tell you where Glencore operates and what does it work and what mineral does it mine. And then if the portfolio committee want to pursue them in those operations, it's up to the portfolio committee. From where we're seated, we are not dealing with any case of Glencore, even when taken by the Guptas in Optimum. That was the issue, even that mine is under NPA, and that's it. So what I will do is to hand over to TJ Mpele to lead the team to take us to the operation, to the body of the report. Thank you, Chairperson.
Thank you, Honorable Minister. Good morning, Honorable Chair, Honorable Members, Honorable Minister, Deputy Minister, Portfolio Committee staff, Team DMRE, and guests. Chair, as the Minister has already dispensed with the introduction, I will then, from my side, not waste time, and I'm going to ask DDG Makobela, who is responsible for mineral regulation, to deal with the presentation that we were requested to come and present, which is basically on the activities of Glencore in the country, specifically in the mining and energy sector. Over to you, DDG Makobela.
Thank you very much, DG. Thank you, Honorable Minister. Honorable Chair, Honorable Members of the Portfolio Committee, Honorable Minister, Honorable Deputy Minister, DG, Team DMRE and Portfolio Committee staff and members of the public. Good morning. As indicated, Chair, I'm going to run through the presentation, perhaps in more detail than running. Chair, we will start with an overview, including briefly on the background, the mining rights issued, Limpopo, Northwest, Mpumalanga, and for each of these provinces, we'll talk about particularly compliance, focusing mainly on financial provision. If we move on to the next slide, the background that we wanted to give is basically that, as the Minister has indicated, the offenses that were referred to were, in terms of the reports that we have received and the documents that we have seen, were committed in jurisdictions outside the South Africa. And we therefore, as Minister has indicated, we have no indication that there was any offense committed in the country. And by the look of things, if one looks into the documents themselves, the investigations were quite thorough and involved looking at all transactions that the company had been involved in. So we have a degree of confidence that the countries that were identified were the countries that were involved. We just want to conclude that nowhere in the agreement, the plea agreement, was South Africa or subsidiaries of Glencore in the country mentioned. So in terms of the Glencore operations, so Glencore, firstly, just by background, is a major investor in the country, employing over 16,000 workers in total, and has got operations in coal, chrome ore, ferrochrome, vanadium, and also produces thermal coal for export and coal for domestic power generation in their mines in operations in Mpumalanga. The ferroalloy mines are located in both Northwest and Limpopo. Vanadium is located in the Northwest province. We also want to indicate that in 2018, Glencore acquired a crude oil refinery from Chevron, which includes the refinery in Cape Town, but also then service stations. And what I would want to indicate in as far as this one is that that refinery then had an accident in July 2020. But what we can indicate is that the repairs are completed and that refinery is in the process of being restarted. Next slide, please. So if I zoom in on the Limpopo operations, just by way of background, the Glencore was issued with a right for chrome mining in 2009, and that right is still valid. It is an underground operation in the Rich Bushveld complex. It's 35 kilometers south of Steerfort, and there are 3 shafts there, the Helena, Machareng, and Thorncliffe. And the mine employs 2,300 employees, inclusive of contractors. The next mine is Grondal Mine, which is a Glencore Merafe Resources venture. And there are 4 mining rights that were issued in 2007, 2008, and 2009, respectively, and all for a period of 30 years in Grondal in the Bujanala district. It is 10 kilometers east of Rustenburg, and there's only 1 shaft, and it employs 800, close to 900 employees, inclusive of contractors. The next one is a Rovan mine. There's one mining right for vanadium, iron ore, silicon, and calcium mining, and issued in 2007 for a period of 20 years. It's an open cast operation, and also in the Northwest province, and employs 720 employees, inclusive of contractors. Then the next one is the Bushhook mine, one mining right for chrome, a maximum 15, issued for a maximum of 15 years. And as you would imagine, this is now is coming to an end, but the 15 years that is. The mine has applied for a renewal during the course of this year, and that renewal
is
still.
Faith, my name is Ivana Chetty. Can I give
Sorry,
my name?
sorry,
Can I give you my ID?
CFO. Sorry. Okay, sorry about that. As I was indicating, the mine has applied for a renewal, which is still being processed. Thank you. Then the next operation is a Waterval mine, and there are two mining rights for chrome and PGMs that was issued. They were issued in 2007, 2008, respectively. They are still valid. It is also an underground operation. However, what we can indicate here is that the mine was placed under care and maintenance. And they are in the process now of developing a new open cast mine to mine UG1 metals. And that, of course, would mean that there are few employees at the moment who basically are looking after the care and maintenance operations. And we are going to be engaging them on the, fast tracking of the development of that new open cast mine. Next slide. Rietvlei is another operation in the Northwest, employing 57 employees. This one is basically a small operation. And it is also in the, 10 kilometers west of Rustenburg in the Northwest. Next slide. Okay, so when it comes to Mpumalanga, you would see that, if we had gone by the same approach that we use for the other provinces, the presentation, in our view, would have been quite cumbersome. But what we wanted to indicate there is that we basically have a lot of operations in Mpumalanga. And we want to show there that effectively all of these are all the mines that, or the rights that have been issued in Mpumalanga. And basically most of those are operational, except of course the Amersfoort, Badegorp, and Consbury, where the operations have not commenced. But we wanted to show that these are the number of rights that have been issued. The next slide also we show the number of, or the number of rights that were issued for different mines. And basically, this is the list that we have, and we want to just indicate that a lot of operations of Glencore basically are in the Mpumalanga region. Thank you. Okay, this one I think is a repeat. Apologies for that. If we go to compliance, so we wanted to show here that in terms of the SLP, there is a valid SLP that is being implemented as we speak. There is, in Tweefontein, there is a workforce of 1,036. In terms of HRD, our inspection has showed that there's compliance. There's compliance also with the employment equity. Because the SLP is new, the LED projects have not yet commenced because it's a new cycle. On housing and living conditions, there is compliance in that mine, as well as on financial provision, basically for LED, HRD, as well as for retrenchment purposes. So there is overall compliance in that operation. Wonden, the last inspection that was conducted was in 2019. And of course, we had to issue a Section 93 for them to correct the things where they were not complying. They have a total workforce of 857. And what was found at the time was that they were not complying on HRD, they were not complying on employment equity. Some of the projects were behind in terms of the LED projects. They were 30% completed at the time. But there was compliance in as far as housing and living conditions, as well as financial provision. We felt that there was compliance there. But those two, they were then directed to correct the areas where they were not complying. Similarly, in the Impunzi complex, inspections were conducted. There were areas of non-compliance. I think we've made a mistake on housing and living conditions. There was non-compliance there. And then on employment equity, there was compliance at senior management and core critical skills levels. Again, some of the projects were not completed. Just that mistake there on housing and living conditions, that should be non-compliant in as far as that is concerned. And then the financial provision, we were satisfied with that. Then on Zonneblom, this is an area where we found quite a lot of non-compliance. And as a result, we had to issue a Section 93 for them, to correct the areas of, they were not complying on LED program, also on housing and living conditions, and as well as the procurement plan. financial provision, there was non-compliance, and they did then submit a remedial plan to correct those issues. Next slide. Then on the issue of financial provisions, we conducted an inspection in 2019, and we verified that the company, one, there was money that was in the trust fund, as well as a bank guarantee that was submitted. The current environmental liability is in the order of 705 million. And given what sits in our books, we believe that in as far as this operation is concerned, there is a surplus. Then on Zonneblom, the current liability is 15 million, and we have a financial provision of 21 million. And therefore, we believe that in as far as the liability is concerned, there is sufficient provision for that. This is one where there is a shortfall, which is quite significant. The liability in the Impunzi complex basically is in the order of 1.3 billion. And we, in the trust fund, we have 943 million. And then in terms of guarantees, there is 243 million, which basically leaves a shortfall of 192 million, which is about 12% of the total environmental liability. And the company is currently arranging to fund the shortfall. Then on the Merafe Chrome mine, the liability was assessed during the course of this year, and the closure costs were determined to be in the order of 27.5 million, and the bank guarantee that we have on our books is 26 million. The shortfall amount, which was determined, was then 1.3 million. And I must indicate that that has since been submitted during the course of the month of September. Next slide. On Krondal mine, there is we have sufficient funds to cover for the liability for now. I wouldn't want to spend too much time on that one. Next slide. Then on the Limpopo one, Thorncliffe, Magareng, and Helena, the liability currently sits at around 158 million. And we have financial provision for 127 million. There is a shortfall to the value of 30 million, which the company has committed to resolving. And we will be following up on that 30 million. Then Waterfall, the current liability amounts to 56 million. and we hold 55.5 million in the form of guarantees, and there is a 1.1 million shortfall. There was commitment to pay the shortfall yesterday, and I can confirm that the guarantee for the company for the shortfall has been issued, and we basically will be closing this one. Next slide, please. Rovan Mine, 223 million in terms of liability, and the bank guarantees amounts to 248.6 million. And so we don't see an issue in as far as that is concerned. And honorable members, yes, there are areas where there is non-compliance that has been found during inspections, but overall, I think we can indicate that to a large degree there is a level of compliance, which with the provisions of the MPRDA, we have satisfied ourselves that operations of Glencore have got BE partners. In the main, if one looks at north or on the coal side, the BE partners are in the main arm, Pembani and Litemba, Vonderfontein coal, and then there are quite a number on the ferrochrome and chrome side, including Mirafe Resources, Bakwena Bamuhupa, as well as Nsimbi is one of the BE partners for the Mukala operation. Now, we also then, when we saw the headlines in May, we did engage with Glencore executive, and all three executives, or one responsible for coal, for chrome, and ferrochrome, as well as the petroleum. And we were assured that, what we read in the documents is what obtains, and that these practices that were obtaining in other countries did not affect the country. And lastly, Chair, we want to indicate that we always cooperate with law enforcement agencies whenever matters of impropriety are raised, and we will continue to do so. Thank you very much, Chair. Thanks, teacher.
Thanks very much, Robert. Honorable Minister, that's the presentation from our side.
Honorable Chairperson, Honorable Luzipo, that is the presentation of Glencore activities in South Africa. I hand over to you.
Thank you, Honorable Minister and your team. Without any further delays, yes, I've noted your apology, Honorable Zungola. Hopefully, we would have done a meaningful interaction with the presentation. Honorable members, I won't start with the issue with regards to what legal services is doing, because we've got our duty to do, and then we will deal with what is the views of legal services. Can I check, are there any questions of clarity or comments? I'm trying to see hands going. 1, 2, 3. 3. Okay, there seem to be no comments or questions of clarity. Oh, I see the hand of Honorable Madogwe. Is there any other hand? Okay, in the absence, let me take Honorable Madogwe.
Thank you, Chair. And I would like to welcome the presentation. I just have a few questions, just one or two perhaps. The first one being I think there are a few mines that were cited as either not operational or under care and maintenance for a while. I do understand that one had applied for renewal, but I'm interested in terms of what are the timelines that the department has actually put in place together with Glencore to make sure that those companies or those mines are operating as a matter of urgency. And this is coming from the fact that in our oversights in relation to mining, to illegal mining in particular, we have seen serious blunders that have been committed specifically by the department, where they've taken a very long time to actually see this to finality, to a point that things such as illegal mining, including what has happened in Krugersdorp to a certain extent, have happened because of such delays. And then the second one, it is on the Zonneblom 358. I understand that in 2019, findings were made, recommendations were made, and the company did put in place a remedial plan. But it's been about 2 or 3 years after that. So I'm interested in whether now, as you are speaking, all the things that were supposed to have been complied to have been complied, because there's a number of issues, very important matters that the company or the mine in particular had failed on. And I would be of the view that a plan is not sufficient. What we're supposed to get is progress reports as well in terms of the things that they had failed to comply on, what have they complied on and what have they not. And then I think as well in the issue of the rehabilitation shortfalls, I do understand that there is commitment to pay or to actually cover that shortfall. But I'm just interested in what becomes the common practice of the department in the event that companies actually falter in rehabilitation funds or in rehabilitating, because in most cases those are the costs that would ultimately be falling on the hands of the taxpayer. So what is the usual practice in the event that companies fail to pay their rehabilitation costs? Thank you, Chair.
Thank you, Honorable Madogwe. Honorable Zungula. Honorable members, next time when I ask, don't wait for one member who will have some lever to make questions. Otherwise, I may not come back and check whether there's still a hand or not, because last time I checked, there was no other hand. Okay, Honorable Zungula and then Honorable Lorema.
Thank you, Chair. My apologies for not raising my hand on time. The presentation, I welcome it and thank you for it. I've got a few questions. Firstly, the presentation I got, or we were emailed, at the top, it indicates that it will talk about mining rights in Mpumalanga, but on the slides, there is nothing that talks specifically about mines in Mpumalanga, unless I missed something. I just need to understand, Chair, how did Glencore acquire Optimum, the Optimum mine? I missed this one as well in the presentation, and also interested in finding out who were Optimum's BEE partners. Then the last question, has the president of the country in his Glencore role ever approached the department for assistance or any transactions or acquisition of mineral rights? Thank you, Chairperson, that's all.
Thanks, Mr. Chair. This is more a comment, I suppose, but perhaps the Minister wants to react to it. And this is a very interesting report, but it suffers from being a self-assessment by the department. Because as we all know, in these other countries, what essentially happened was officials were bribed by Glencore. So the department in this report has taken a look at it and said that Glencore appears to be complying. But that is the report of the department on its own behavior. It isn't an independent report. So it's interesting as far as it goes, but it seems to me it's just not a complete picture, because we still don't know whether there's been safety offenses or even licensing was assisted by being bribed. This report doesn't tell us that. So whereas it's interesting, I don't think it's the full story.
Sorry, can I give to the Honorable Minister and the team?
Thank you very much, Honorable Chairman. We have tabled a report, not self-assessment. It's a factual report about what is happening in mining regarding a particular mining house. Now, if we didn't do that, what else would we do? Should we go and look for bribes if there are no reports of bribes in the department? I don't understand that approach, because it means you're expecting the department to be investigators. We're not SIU, we're the Department of Mineral Resources and Energy. We give you factual reports. Honorable Zongula says there was nothing on Mpumalanga. There was a big detail on Mpumalanga, unless Honorable Zongula joined the meeting late. The bigger part of the report covers Mpumalanga and mines there. And you will see that if you look at the mines in Mpumalanga, they tell you that Glencore is a function of measures. That's why you find mines that used to belong to Daycare, for example, are now in Glencore. And that report is detailed here. The shortfall in paying a rehabilitation fee, maybe, Honorable Makuben, you need to explain to the portfolio committee how rehabilitation funding goes, the difference between ownerless and derelict mines and concurrent rehabilitation. If you give that explanation, I think it will help us a great deal. But what I should do, I must give Honorable Makubela and DG to give responses to particular operational issues. And if there's anything left, I will come back later.
Thanks, Minister. DG Makubela will take most of the technical questions, and then we'll come back if there's any that is left.
Yeah, thank you very much, DG. Thanks, Honorable Minister. Let me start on the issue of care and maintenance. So we have regular interactions with Glencore and any other company, particularly those that have operations under care and maintenance. So whenever we don't like mines that are in care and maintenance. However, this usually is a function of the commodity prices. And we have no concern at the moment about the length of time some of these operations are going to be under care and maintenance. We will follow up and maybe we can come back with the timelines as to when these operations will be removed from care and maintenance, because at the moment the commodity prices are favoring the restart of operations. On the issue of the rehabilitation funds, as Minister has indicated, So we have two sets of, mines in the country. You have those ones where there are no owners, they date back decades. And these, you can't trace shareholders, you can't trace the owners. And we call these ones derelict and ownerless. And these ones are the ones where basically the state has taken over the responsibility. However, for operational mines, they have to do what we call concurrent rehabilitation. So we evaluate the liability and say that for this operation, this basically is what you're going to require to rehabilitate. And we need a guarantee for that. You need to make financial provision. So as they rehabilitate, effectively, then that guarantee gets reduced because they then have, they have rehabilitated a section of the mine. So this is a practice, and we don't believe that if we are vigilant, we will have any of the current operational mine falling into the category of derelict and ownerless mines. Now, as you can see, where we have identified shortfalls, we have then asked the company, particularly the case here, but it applies to all the other mining companies. We have said you need to make good, you need to top up your provision. And as you can see from the presentation, top-ups have been done. I think there are two operations where we are still waiting for top-ups. And some of these, as I indicated, one, the commitment was for yesterday, and we received that. The other top-up was done in September. And this followed an inspection that had been done. So our teams go out to go and inspect. And when they do the inspections, basically, these are some of the things that are on the checklist. And where there is a finding, then the mine is then issued with a directive to make the correction. On the issue of whether we have been approached, what I can indicate is that our system is such that you need a lot of collaboration, as it were, to have any sort of wrongdoing. Because the way we've structured our systems now is that we have a committee that evaluates basically each and every license. And that committee is made up of people from different divisions of the department. And those are some of the checks and balances that we have. So we do not have any concern at the moment in terms of our system. On the issue of the optimum mine, I think I would need to because now that mine is no longer with Glencore, I would need to come back on the BE ownership on that one. Thank you, Dish.
Thanks, DDG. Minister, those are the responses from our side.
There was a question from Honorable Songola whether the president ever approached the MRF for licensing. I think we should give Honorable Songola basics of licensing. There's an application for a license.
I'm not sure whether it's me who is cutting, Honorable Minister,
now,
or it's your side.
You are cutting. It's you who is cut.
Okay.
Yeah. It doesn't matter what your views are about Honorable President, Honorable Zungula. I have no picture of BE partners being agents of pressing for licensing. If I'm a BE partner for a company, that's a relationship between my company as a BE company and the company that holds the license. So this thing of approaching a DMRE for licensing would be unimaginable. Let me just explain that. You may have your views about it, that you may be going all over, trying to open up things for Glencore. In this case, it's a misplaced question. Thank you.
Thank you, Honorable Minister, and the DMRE team. Maybe let me say I understand the issue with regards to Honorable Zungula. Yes, in the initial presentation that was sent, the issue of Mpumalanga was not there. Subsequently, they had to rectify that, and in the presentation, it is contained in the presentation in Mpumalanga. I think it's the last one on the activities of Glencore as far as mining rights are concerned. I think just few things. I see your hand, Honorable Madog. I'll come back to you. I think just few things, Honorable Minister, probably if we may get clarity, because the first thing is that in terms of the findings, let me put it like that, in terms of the findings in many of these areas, what become an issue has been, which I think the committee will have to also confront this issue if it feels it needs to be gone detailed. The cases which led to confessions have been through criminal procedures in most of these countries. For an example, if you look at the US case, it has been handled by the justice side of the state, which means it would have been in the South African context, been handled by the judicial system, in particular the NPA. That's how I understand. And that concession, or call it a plea bargain, was through criminal procedure, not necessarily internal processes of the states, in this case, in the US or any other part of the continent. Maybe that is one thing I would say. Has the department ever considered looking at whether in the South African context, is there such a process that is being considered? I know I'm asking for the benefit of the committee because it will be difficult to ask the Department of Justice and Correctional Services through its prosecuting wing, whether are there any prospects or processes that seeks to attend to the issue in the same way it had happened in other countries. The second one is that according to, it might help as the department, and I think also again the portfolio committee, the matter might come back to it, considered or gone through the Zondo Commission report, and is there any matter specifically in that Zondo Commission report that talks to, let me say in inverted commas, manipulative systems that sought to advantage, especially the multinational, in this case with specific reference to Glencore, because that's what the topic or the brief is about. The last two things may not necessarily be linked to the brief, but one would maybe get the privileged information, both in the Zondo Commission report and the NPA. But the first question would be, has there been a complaint on record from Glencore on how they were squeezed or they were forced to forgo or sell the optimum or undue pressure that was put? Obviously, may not be you, Minister, or the rest, but by either your predecessor or predecessors. Has there been any records of a complaint on an undue pressure that has been put on them to sell optimum, and the role that the department would have played in that exercise, in that process? So linked to that now is has the department had any shared information on the status of optimum mine with regards to the issue of the asset forfeiture processes by the NPA? And the last one will be, what is the attitude of the department currently? I know we respect the independence of the judiciary. We respect matters that are sub judice, that are in court. But has the department considered maybe looking beyond the criminal case that involves the former DDG of the department with regards to other possibilities of manipulation or individuals who would have been in collaboration with what today we know to be the case in front of the court? I think that those issues probably may be able to assist the committee on how then it develops attitude going forward on this matter. Let me then also give Honorable, I saw is your hand still up, Honorable Madogwe, as a second bite?
Yes, Chair, and thank you very much. I think now you have covered something that I'd wanted to cover, but nonetheless, another one that I wanted, maybe I might have missed it, but I do not think so. I do not remember getting a response on the current status of Zonneblom 355, because what we are getting there is that a remedial plan was submitted. So of all the non-compliance issues that were there, what is the current status currently? Thank you, Chair.
Okay, Honorable Minister and the team, your team.
Makubela, Janapala. Makubela.
Thank you, Honorable Minister. On Zonneblom, what we have is a remedial action plan, and we can provide an update on that. I don't have that update on hand currently, but they did submit a remedial plan. Thank you.
Did you?
Minister, nothing from my side to add. I think
Okay.
that was that one. All I can say, Minister, is that we've noted the other points raised by the chairperson, and I'm going to propose that chairperson will respond. I think some of the linkages that around your questions, we probably respond to those in writing.
Okay. But Honorable Rosep, I think the portfolio committee is expecting ourselves to do something we're not. I have a sense of that we should be a part of the criminal justice system. We are not. For example, questions say the cases in the US, Brazil, and all other areas were a product of the criminal justice system. And the question is, what do we do about that? We're expecting, if there are issues, we're expecting our own criminal justice to do the investigation. If the portfolio committee suspects some of these criminal activities, it has the investigative capacity and power on issues regarding operations in the department. But the expectation that we account for what falls within the criminal justice system, I think is stretching us beyond our responsibility. And therefore, that process will not find in the GMRE because it should not be in the GMRE in any way, because when it is investigated, we make findings even about the department itself. Because I can't stand here and say, nobody in the department manipulate process. I can't say that. But if there's investigation, it may find that some people in the department do manipulate processes. So the criminal justice system must do its work, and we cannot be expected to do it. For example, the Zondo Commission. Zondo Commission is a judicial commission of inquiry. Its findings should be pursued, and there are institutions that have been put to pursue those findings of the judicial commission of inquiry. And one of those institutions is not the MRA. I don't know if there is any formal complaint about how Glencore was put pressure to sell Optimum. But if we follow the Zondo Commission, you will understand that at that time, there was a trip to Switzerland, which culminated in the selling of Optimum to the Gupta. Again, that is an issue that can be investigated following the findings of the Zondo Commission. And I think that is it. My plea, Honorable Jefferson, is that the committee must not expect us to be everything. It must expect us to do what we should do as a department. I appeal. Thank you.
Thank you, Honorable Minister and the team. Let me help you. The point, I think, no. We're not saying the department must be the investigation. The point is that the committee needed to establish, for an example, whether the department had been approached, but I get it from the answer that the department has never been approached or has not yet been approached by the Justice Department or the NPA with regards to the complaints on the conduct of Glencore. That's the point we just wanted, so that the committee then will be able to say in the final analysis, with what we have discovered is that there has been no complaint that has been made or any approach by the law enforcement agencies with regards to the conduct of Glencore in the Department of Mineral Resources and Energy. In the same way, with regards to the Zondo Commission, the point that is that I can say from where I'm sitting, there has been nothing that reflects an undoing conduct outcome of the Zondo Commission, but the committee is at liberty to engage with that report if it finds, as it is now in the public domain and is sitting with Parliament. The last issue with regard with Optimum, again, that's not what the question, the matter is. The matter is to establish whether, as far as the records of the department, has there been a concern or complaint lodged with the department on the conduct that would have been led Glencore and to sell even when they never had the intention. But I get it that there has been, if there is no such in the department, it then helps us as a committee to then say what then becomes the way forward. And I think, I take it that the department is talking about what is contained in its records, which in our view, it will assist us. Then moving forward, we will then be able to say, this is how we think the matter has to be handled differently. I think that's the context we're seeking clarity so that we take an informed decision as a committee or recommendation as a committee. You want to come in, Honorable Mahlaule, before I give the minister to make the closing remarks on this matter?
Thank you very much, Chair. Greetings to the Minister, greetings to Deputy Minister and the DG, and greetings to my colleagues. Chair, I think we have made a small mistake in this discussion. I had thought that after the presentation, we would allow an opportunity where the legal services of Parliament comes in before we engage the discussion, so that they outline what the DMR can and cannot do, so that we discuss what it can do and what it can't do from the perspective of the law, and so that we don't have a situation where the department or the minister feels that we're stretching the department or their role over that of the law enforcement agencies. It would have been outlined that this is where you can go, this is how far you can go, and this is where you can't go, so that we're on the same page. You know, right now, I doubt that we are at that level, and my view is that we do not allow the guidance from a point of view of the law to arrive where we would want to arrive. Thank you very much.
Okay, thank you, Honorable Mashale. But that's what I raised initially, that we will give legal services. But you will recall that legal services, before we undertook this exercise, even what they will be presenting, it will be just to refresh our own minds on what they had initially briefed us on the way forward. But I think we can still, we will be able to handle. Maybe let's request also, even if the minister is released or whatever, that at least somebody from the department in a position of authority can remain behind, so that if there is a matter when we deal with what legal services is debriefing us again on, then they can be able to interact with that exercise. Can I give then the minister to make the closing statements on the presentation, and then we will go to the legal services debrief.
No, thank you very much, Honorable Chairperson. My starting point is the committee has oversight responsibility over what we do. That we have accepted. In other words, when the committee say move right, that goes. If it says go left, that goes. We give an explanation when we're required to give an explanation. What I think we should avoid is where we entangle the work of the department and the committee to a point that there's no distinction. The committee has a right to do investigation. The committee has a right to commission anything. And in that process, I would imagine that the committee will call the department to account on areas where it must account. But it can't be the department that formulates issues that must be accounted for by the department. My appeal is that let's separate those two and allow the department to continue respecting this committee, so that when you call us, we must feel that we're called by the oversight committee and we suspect nothing. That's it. Thank you very much, Honorable Chairperson, Whip, and members of the committee. Thank you very much.
Thank you very much. Can I then give his legal services? I'm not sure who's leading the team. Is there someone from legal services? Molo Tatunyonso?
No, Chairperson, there's no one from legal services.
Molo Tatunyonso?
Chairperson, may I assume that we stand released?
No, you are released, Minister. You can leave one person of a little bit of authority. You are released together with your TM. Can I ask Sifu just to flag the so that when members talk to just flag the legal services report, so that we either agree now, honorable members, on what should be the way forward, or I'm subject to your guidance. We agree that when we deal with matters arising, we also take into consideration the legal services. But I know that legal advice was only received in June, if I'm not mistaken.
August.
But I think also it's important just to state that, unfortunately, these are some of the things that are not of our own choice. It was based on the matter being referred to us as a portfolio committee. Is there someone who wants to give us a summary of what does this legal? First, let me get the guidance from honorable members. Do you want us to deal with it now, or do you want us to deal with it when we deal with matters arising on how do we take the process forward from here? I see the hand of Honorable Malinga. Is there any other hand? Okay, Honorable Malinga.
Thank you, Chairperson. Greetings to yourself and everybody on the platform. Why, if maybe, Chairperson, if because I did not hear the apology of the legal services, how can we deal with their document when they are not there? When they are not here, why are they not here? Maybe if I can get that clarity first, Chair. Thank you very much.
Okay, the clarity is that they had already presented the document. I hope that's what they understand. They had already presented the document to the committee, and therefore the matter now rests with the committee as part of the proceedings from that legal advice. But Ari, let me get it from you and Ayanda.
Thank you, Chair. You are correct, Chair, the way that you explain it. They were not invited in this meeting on the thing that they are supposed, because they already represented their document. So they are not aware that they should form part of this meeting. Thank you, Chair.
Yeah, honorable members, the document they came to, which is why we then had this process of first engaging asking the department to make presentation. They did give us the presentation on the document. We then agreed that we must write to the department so that it can come and make presentations on whether there is knowledge. Subsequent to that, we then have to agree on what then becomes the way forward. So the legal advice was presented. When was it? We just put it here as a reminder to honorable members. That's why I said, even Sipu, who can remind us, but in summary, on what then we can do, or this committee could do, or we agree that when we deal with the matters arising, that's when we will deal with the way forward on what do we say or has to be done with regards to the issue of the presentation on Glencore. Can I get someone who can help us? Or you want to come back, Honorable Malinga, with that clarity? Okay, Ari, can you summarize the legal advice as per the submission made in June? Yes.
Thanks, Chair. Now, just to give the advice from the legal opinion, paragraph 18. In view of the above, it is our opinion that on the issue of Glencore, the committee is at will to schedule a meeting with the minister and call on the minister to undertake a review of all Glencore mining licenses and contracts awarded by the DMRE in South Africa. The committee is also at liberty to recommend to the minister that such a review should include a forensic investigation by an independent body or entity. So that's in a nutshell the advice from the Parliamentary Legal Services Chair.
Now read 19 also.
19, the committee is not in any way restricted if it wishes to undertake a review of governance issues at the DMRE regarding the alleged misappropriation of the mining rehabilitation funds by the former DDG and other officials for that matter, even if it overlaps with the issues before the court. However, the alleged criminal conduct of the DDG should be best left to the courts to settle. That's it. Yeah.
Okay, honorable members, with regards to 18, because all this we have done what 18 is advising us. The minister today came to brief the committee on all the issues that relates to Glencore, including licensing and contracts awarded. That's what this exercise was about. We have undertaken that. The issue now is, which is why I was saying, should we give honorable members an opportunity to go back, process this, and instead of scheduling this as an item, we then say when we deal with matters arising, we will then be able to say what then becomes the way forward. Do we take this matter as closed based on the fact of the information that we have, subject to what then will be new revelations or new information that has been found contrary to this? Or do we take this as a matter that is now at the hands or be referred for the attention of the Portfolio Committee on Justice, as we have got nothing that we think is untoward in terms of the normal or daily operations? Can we then leave that to members to take into consideration when we deal with the matters arising? Is there anyone who wants to support that? Honorable Mahlaula, I see your hand. I don't know whether Honorable Malinga is a legacy hand. Honorable Mahlaula.
Thank you, Chairperson. It was precisely for this issue that I said we have made a slight mistake by coming in as members before we go to this point. Yes, the minister was here, and we had a back and forth about what he can do and what he can't do. And there's an advice that says to us, the minister can undertake a review of all Glencore mining licenses and contracts. If we had allowed this to be brought to us when the minister was still here, we would take a decision as the committee whether we want to have the minister reviewing all these mining licenses or not. When we say the matter must be on the matters arising, I don't think we'll be doing justice, because here is an advice that says the committee must take a decision whether we want a review of all Glencore mining licenses and contracts or not. If we take a decision today to say, are we recommending to the minister to review and include forensic investigation by an independent body, that's a decision we must take, and we must have the minister implementing what we are saying is our decision. If we decide not to do it, the matter is closed. The second issue as well, on 19, what is the role of the department on this issue of misappropriation or alleged misappropriation of mining and rehabilitation funds by the DDG, the former DDG? Yes, it's in the hands of the courts, but what then becomes the role of DMRE? And when I speak about the role of DMRE, there is in law, as much as I'm not a law person, where departments of or persons become friends of the courts to see to it that what has been done wrong is taken up until to its logical conclusion, and they are there to monitor the situation up until, and they are there to support and give information to the law enforcement agencies and so forth. Now, to leave it like this and say we're going to, because there are monies that needs to be recouped here from the former DDG. How you deal with that is a matter of this committee to decide upon this advice that we are given, what would be our the department's role? That it would have avoided a situation where the minister feels that we are forcing a hand in one way or the other. But this is a legal purview, and it says we can take a decision to say to the minister, go and review those licenses or not. Thank you very much, Chair.
Okay, I'm not sure, Honorable Marshall, can we go up? Maybe we may not have the same understanding, but let me take honorable members, when we dealt with the issue of the car powership, whatever it is, one of the things by procedure, because we are implementing Section 18, I just want to check the date on the 25th, ne? Am I correct? I want to check this.
2030.
23rd, yes. On the 23rd, we received a briefing by legal services. Legal services then said, let's go now to the leave where it then responds to all the basics, the questions and what is it, they analyze, then they go and let's go back to 18, Ari. Let's go to 18. On 18, it then advises us. There, yes, it says, in view of the above, it is our opinion that the issue of Glencore, the committee is at will to schedule a meeting with the minister and call on the minister to undertake a review of all Glencore mining licenses and contracts awarded by the DMRE in South Africa. Then it says the committee is at liberty. Also, the committee is also at liberty to recommend to the minister that such a review should include a forensic investigation by the independent body. Now, if you look at the first sentence, that's exactly what the advice says. Call the minister, let the minister brief you. The only part that is an issue, which for me, I would say, it should then form part after the minister has presented, is whether there is a need to review all Glencore mining licenses and contracts. So the minister now is invited to that platform to give an account of the activities of Glencore. That's what this advice in summary says. Having done so, it then says the committee is at liberty. After the minister had made that, the committee then is at liberty to then make these recommendations. And I'm saying that review for me, it can only come in after the minister has done the presentation. So the first legal advice is to invite the minister. Now let's go to 19. 19, it talks to the issue of the rehabilitation funds. The committee separates the two. It says the issue of rehabilitation funds, we will receive a presentation by the department. It's still coming. It's on our schedule. It's scheduled on rehabilitation funds. Based on what then will be briefed on the status of rehabilitation funds, including the case of the DDG, the committee then will take a decision or make recommendations. So at this stage, we have done what phase one of what the legal advice says. We have invited the minister. My suggestion was that, do we need now to sit down and have an item on the same matter that will then take and make recommendations from a committee point of view? My take is that it will be too long, but when you deal with minutes on matters arising, You then put in that on these issues, we are recommending, for instance, we are recommending that there must be a review of all the mining rights and contracts to Glencore. But secondly, we are recommending that there must be a forensic investigation. But if we say there must be a forensic, which is why I wanted to allow members to go, if we say there must be a forensic investigation, it must be subject and be based on a tangible prima facie case that there are certain things that are acting untoward. And the point I was saying was that from where I received from the department is that there is nothing that they've received, even from the Justice Department, whether NPA, that there are certain things that are not going well, going okay. And in that situation, if we agree on that, then we may have to take a decision. What do we do? Do we want to proceed, and in what form are we proceeding? Or do we want to refer the matter to the Portfolio Committee on Justice, simply because it only deals with investigation? And I think I may agree with the minister, which is not what was intention here. We needed to get an overview, a general information. If it then requires some investigation, definitely it may not, I don't want to preempt, we may have to convince ourselves why do we think it does when there is nothing that is a prima facie case of any criminal offense that we have discovered now. And that for me can only rest with the Committee on Justice. And then we may have to compile the report, take it back to the House chairperson who has referred the matter to the committee on what do we think has to be done. That was the suggestion, to say, maybe we should not deal with the issue now. Let's go back and go through all the presentations and what the ministers are counted on. Then on matters arising, we suggest the way forward there. Then we leave the part of the rehabilitation. I was just bringing it in so that members can see that in the advice, it was advice on two issues, rehabilitation as well as the issue of the allegation against Glencore. I'm not sure whether I tried to explain enough on the matter. Honorable Matogwe, I see the hand of Honorable Malinga. Is your hand up or an old hand?
It's up, Chair.
Okay. Honorable Matogwe and then Honorable Malinga.
Thank you, Chair. Actually of the view as well that there's no need for us to refer this to another meeting or to the matters arising as the chairperson has advised, but rather that we have more than enough time. We might as well just put this matter to its conclusion. Understanding, of course, that the advice, the first part has been done. We've received the report from the DMRE or the minister. But I'm also of the view that we are also, and we were also, by the way, when we started or undertook this process, we're operating under the premise of where there is smoke, there is fire. And therefore, we would need, as a country, and also as the Portfolio Committee, to also satisfy ourselves that there was nothing untoward that was done by Glencore in South Africa. Because the report that is there and what is there out in the public, including what Glencore has confessed to, we do not at this point in time have a guarantee that there was thorough investigation done in South Africa specifically. It could have been that there were areas of interest, and it could have also been that they had chosen which areas or which countries they chose to confess or to admit that they had done corruption in. Secondly, I think even the minister and the department, they said that as they are standing right here, right now, they cannot confirm that there is nothing untoward that was done by Glencore, because such an investigation was not done, especially to that level. I think what even the report that we got today was just an overview of the operations of Glencore, including, by the way, just the general ones. But even in those general ones, hence I kept asking about the issue of Zoneblock and why at this point in time we're still being told about a remedial plan, and how is it that that particular mine had been operating without actually having done the most basic things that was requested of it. That on its own, to a certain extent, must give us a red flag that something untoward is happening. So that being the case, it is very important whether I don't think there should be a problem with us actually recommending that there must be an investigation that is done by an independent body, as advised by the legal team, but also referring this matter to the Justice Department, because I think that as a country that prides itself to be against corruption, and a country that places itself as a champion of justice specifically for Africans, I think that to a certain extent we do have a responsibility to make sure that everything or every company that we are doing business with as the country has not in any way victimized or in any way disadvantaged not only South Africa but other African countries as well. And there is actually the report or the recommendation as well that has been given by the report done by the research unit, where they also recommend that perhaps through the government structures, maybe the NPA and the SIU must be given the responsibility of investigating Glencore as well, which is something that the portfolio committee should perhaps also consider considering the fact that DMRE does not necessarily claim that they do not have the powers to investigate themselves. But we do have organs of the state that have that sole responsibility. And as the portfolio committee that actually took up the issue of Glencore, I do not think that we should just necessarily just pass the buck to the Department of Justice, but perhaps we could do a joint operation or something along those lines. And I think also with the matter of the DDG, something must be done. I understand that the chairperson has indicated that we are still going to get a report on the mining rehabilitation funds, but this report is very clear as well that just because there is a matter before the court, we are not in any way restricted from undertaking some of the governance issues that are in relation to DMRE. And perhaps DMRE, speaking also to what Honorable Mahlaula is saying, that it must be taken to task to actually account to in terms of what have they done specifically, what is their role as the department in the whole issue or in the whole debacle that deals with the misappropriation of mining rehabilitations, and also considering the fact that the person who is implicated is a DDG, which would actually be considered one of the most senior officials in the department. Surely it cannot be that the department is just found wanting. What are they doing about that, notwithstanding that the case is before courts? And had that case not been taken to court, we were just going to continue with our lives as if nothing had happened. Thank you, Chair.
Honorable Malinga.
Chairperson, thank you very much. I was covered by Honorable Mahlaule, yourself, and now Honorable Madogwe, especially on the last point of the DDG. We can't just go as if nothing has happened. The matter was brought here. We were advised, though they say we must leave the matter to be settled by the courts, but the department needs to tell us whether the DDG is under suspension with pay and whatever. But I think that will come with the report that you are talking about of the rehabilitation or mining rehabilitation funds. So I am basically covered. Thank you very much.
Honourable members, because I was trying to avoid this, let me start, I'll come back to this one. Can we then say through the committee, we will compile the report and say the committee has been able to convene the meeting as they has made the minister to come and take account. We are of the view that based on the nature of this matter, that this matter will best be suited to be handled by the Portfolio Committee on Justice and Correctional Services. And as the Portfolio Committee on Mineral Resources, we are prepared and avail ourselves to work very closely and cooperate with any other processes that will be undertaken jointly with the Portfolio Committee on Justice and Correctional Services. Then we leave that matter to the House Chair It means now the nature of what it will take will be guided by the portfolio committees, as they will then agree on what then becomes the way forward, or subject to the approval of the House chairperson at the same time, because this is a mandate, it's not our choice, this one. Unlike the one when we're dealing with the issue of the risk mitigating and independent power producer purchase, that was our own initiative. This one is referred to us by the House Chair. I thought either we give a progress report on how far we have dealt with the matter, and then look at the options available. I want us to deal with that. The second thing, I agree, let's take the issue of the rehabilitation fund to its proper meeting. But I hope members are aware, the issue is about former DDG. If you look at 19, the DDG is no longer there. I think it's more than, if I'm not mistaken, it's more than 5 years now that he left the department. The point, though, was that if you then, when we get the actual presentation on rehabilitation funds, that is then that we may know the extent of the challenge and how, if this thing had happened, not just that it had happened is in court, how it had happened, what are the possibilities that there could be many others that are similar to this. So at this stage, we don't know. That report has not been tabled. So I want us to deal with the first matter. If we don't agree on that, it will mean then let's take the matter to the next meeting, which we may find it very difficult to table it as a standalone item, which is why I was making the suggestion with regards to matters arising. So do we agree, which is I think was what Honorable Madog is saying, that the matter, because we have on our part played this role, but the next leg that will be required is how then does the matter is taken forward, and in this instance, it will require on the Portfolio Committee on Justice and Correctional Services. Unfortunately, we can't refer to the Department of Justice and Correctional Services. There is a Portfolio Committee responsible for that. Do we agree on that proposal? Going one. If there is no answer, it means the matter still stands as it is. There is no decision or view on it. Going one.
Chairperson.
Yes, Honorable Maling.
Are you saying we are stepping off the item if we taking the matter to the Portfolio Committee of Justice? It's no longer our issue. I thought we're calling for us to work together with the judge to resolve the issue, because advice number 18, Chair, they said to review all mining licenses. Has the minister done that? The department has come to give us the mining licenses where Glencore hold rights. But have we satisfied ourselves that maybe I know that the department is not the SIU or NPA. We don't want this to come and bite us back, Chair.
So why are you not agreeing then, honorable members, that let's take the matter, when we deal with matters, we then agree what should be the way forward?
Thank you, Chair.
Instead of taking a decision now. That's what I was trying to explain to members. Now there's a proposal that says, no, because there is a need to go beyond what the department has done with regards to what could have been the conduct. Let's take the matter with the Portfolio Committee on Justice. But the Portfolio Committee on Justice, we must then be able to say, in as much, that's why I said, that recommendation, that process for me is that it gives certainty. We must give grounds. Why do you review the mining rights and licenses and even contracts awarded? Are we satisfied? Is there something from what the department has presented that demands that we should do that? You can only do that when we discuss now what should be the way forward based on the presentation by the department. Can we agree to put this matter and then deal with it when we deal with matters arising and see whether even the minutes are a true reflection of what was presented and was discussed in the committee. Can we then deal with that? I just need someone who will move. If it's not moved, then it means it stays as it is.
Okay, Chair, I'll move.
Is there any seconder?
I will support.
Okay, is there any objection? None. Thank you very much. Can we now go to the minutes?
First, the correspondences, Chair.
Oh, okay. I always thought it's minutes first. Let's go on the correspondences.
Thanks, Chair. So I'll just provide a brief summary of the correspondences received. We've received a correspondence from the National Nuclear Regulator informing the committee of the appointment of the CEO, Mrs. Dion Homo. Then we've also received a correspondence from Mr. Rory Tanner from Value Space. Just quickly, Chair, Value Space conducted a risk assessment on the Jagersfontein Dam collapse and has the following summaries. The deformation on the southeastern wall breach point was detected from 2019 onwards. The thresholds outlined by industry as the trigger to conduct an immediate stability assessment to fix the dam were passed in April 2021. The mine was sold in April 2022 to Star Gems. It is unclear whether any analysis was conducted on the dam upon this sale. They've also included an analysis report to that effect, Chair. Then we've also received a correspondence from Tau Rapulana Royal Trust. They've indicated that it was in a follow-up of a complaint lodged in May 21 against Lafarge, South Africa, operating in its area without discharging its legal obligations. Then we've also received a correspondence from Mr. P. Sedejo from Simapa. Simapa, as the minority black shareholder of Swartkop Sea Salt, is requesting an urgent intervention to compel the company to rectify transgressions pointed out in 2020 by the DMRE Eastern Cape. The DMRE Eastern Cape issued an order of non-compliance against Swartkop Sea Salt in December 2020 after a routine inspection finding the company committed several transgressions. From this order of non-compliance, it is clear that the rights and benefits of the black minority partner of Swartkop's Sea Salt, namely Simapa, are severely harmed and reduced. The longer these injustices prevail, the more severely Simapa is impacted. Then we've also received a correspondence from NEDLAC. It was a letter and a NEDLAC report on the ERA bill from the Executive Director. Then we've also received a correspondence from Honorable Milam, where he requested the Portfolio Committee on Mineral Resources and Energy considers convening a joint session with the Portfolio Committee on Public Enterprises. The objective is to summon Ministers Gwedi Mantashe and Pravin Gordhan in their capacity as members of President Cyril Ramaphosa's National Energy Crisis Committee, NECOM, as well as all other members of the NECOM, to come and account for the country's worsening electricity crisis. Then we've also received a correspondence from the organization Outdoing Tax Abuse, OUTA. OUTA wishes to present you with the organization Undoing Tax Abuse report on parliamentary oversight for 2022. OUTA's comprehensive report, Kicking the Can Down the Road, was compiled by OUTA's Parliamentary Engagement Office and covers the period July 21 to June 22. We've also received a correspondence from the NT Zamazama Central Committee. raising issues of illegal mining due to the unrehabilitation of mine shafts in the Welkom area. We've also received a correspondence from the ESCOM board chairperson requesting the postponement of the joint oversight visit to Kuburg on 21 October 2022. The chairperson requested a meeting with the ESCOM board on either 2 or 3 November 2022. That's it, Chair. Those are the correspondences received.
Okay, let's go to correspondence number 1. It's just for noting, I guess. Is that? Yes, it's for noting, I guess. What is your take, honorable members, on correspondence number 2? Can we refer this matter to the House Chairperson, because the issue of Jagersfontein for now cuts across the entities, and then they determine how they will handle this matter, or to the, are we allowed maybe by procedure, Ari and Ayanda, to refer the matter to the Speaker?
We can, Chair.
Okay. And then it must be accompanied by an explanation on the matter with regards to the report submitted to the National Assembly. The issue of Mr. Rapulane, is it Titau Rapulane Royal Trust? What's your advice? Honorable Matoge, I see your hand.
Thank you, Chair. I think with this one, can we maybe find out what is the status on the initial complaint that was lodged? And I would assume that the DMRE would then have to give feedback on that. And then depending on their response, then as the portfolio committee, we can then respond to Mr. Dow.
Okay, can we then agree that the matter will be forwarded to the department and then a response be tabled? Or you agree, you empower the chair and the committee staff to, if there is a need, to action the matter in the meantime and give account to the portfolio committee with regards to the progress? Okay, can we go to the issue with the side go? I can safely say, honorable members, on this one, I've been able to talk to Mr. Sideco. One of the problems I raised was that if it's a commercial transaction of who owns what, that becomes a problem. But with regards to DMRE having to effect compliance with regards to mine health and safety, that is the issue we're taking up. I'm engaging with need to engage with the principal inspector of mines to see what can be done. If it means then there has to be a meeting with the principal inspector or somebody appointed, and the directors and the regional office with regards to compliance issues, or even if it's not the directors, but with the regional office, then we will handle the matter in that fashion and then report back to the committee. But it's going to be very difficult to interfere on the issue of the shareholding dispute that exists. But the MRE, regardless of what happens, they just have to comply and make sure that they effect their authority as far as mine health and safety compliance is concerned. Can we leave at that, honorable members, if you so agree? Going one.
It's fine, Chair.
Okay. Can you agree that the net debt letter is for consideration? Is noted, not consideration. Okay, in the absence, it is noted. The issue with regards to the letter from Honorable Milam, I must say yes, where it is also stated that on the other side, on the letter, he stated that his colleague or counterpart in public enterprises wrote a similar letter to public enterprise. Can I get your comments or your views, honorable members?
I didn't quite catch that. Could you
Chair.
please?
Honorable Mashaule?
Thanks, Chair. There are two things that we can do on this request, because it requests two ministers from different portfolios, and in different capacities than as Minister of Mineral Resources and Energy. So what we can do is, one, we can table the request in the joint portfolio committee that will take place, I think it's tomorrow, where we meet the board of ESCOM, because that will be a joint sitting. Or we can refer it to the authorities that can summon or invite the two in their capacity as the National Energy Crisis Committee. Because I'm afraid if we were to call them in that capacity, are we not calling the president? There are some kind of legal issues that I'm sensing may kick in, and we face problems there, because they are members of President Cyril Ramaphosa's National Energy Crisis Committee, and they are members there. They are not chairing the National Crisis Committee. So we need to be careful on that one. But we probably need to table it to the joint study group and take it from there. We can't table it separately, because if we agree this side, that other side of public, what is this, public enterprise, do not agree, or they agree but different dates and time. We'll have a back and forth kind of granting the opportunity to have these ministers coming. So rather wait for, I think it's tomorrow's meeting, I can't remember, where it's a joint committee and we make a request there, but with a caution that I've just mentioned. Thank you very much, sir.
Is there any other take? Honorable members, can we take what Honorable Mashaule first? Because the matter touches public enterprise, I will interact with the chair of public enterprise. But like you say, Honorable Mashaule, the issue is that we may agree and the public enterprise may have to take their own decision not to agree on the matter. Not to agree on the matter. Or like you say, we may have whether the dates we can coordinate. But I think because it is raised, we must be open to put it. Two, I think for us, in my view is that in the meantime, let's refer that letter of request either to the speaker or to the House chairperson, and then we get guidance on the matter. I don't think it requires legal services. If the House chairperson says yes, invite them. Unfortunately, again, we only have got control over one minister, which is our own minister on DMRE. Not if public enterprise, it will be subject whether they agree. There could be other ministers that are central. For instance, the Minister of National Treasury, which the question could be, why are you leaving them out? And these ones, and you put them only for public enterprise. So I take the point that you are saying the only guidance we'll get now, and if the committee agrees, is to forward the letter both to the House Chairperson and or to the Speaker to get guidance in the meantime as a portfolio committee. Then we will still also put this matter to the joint portfolio committee meeting tomorrow. But again, I'm not sure how much weight a joint portfolio committee, how much weight does it have on individual committee decisions or recommendations. But let's agree that we will do so tomorrow. Can we go now on the next one, which is the outer one? Is there any take? My only take, and I'm saying this with we just had an engagement with Outer, taking them through on how the committee works and our appreciation on the issues that are being raised. Now, if we and please, you must help me. If every civil society formation, every time they undertake an assessment and evaluation of the performance of portfolio committees, then there has to be a meeting. My understanding was that those are being done in order to give those members the need to relook and review how they are managing their portfolio committee work. I'm not sure now because we've not gone back again to them and said this is what we're undertaking. We may have to find ourselves statutarizing something that is not necessarily there that every time. And what then happens from when another entity of civil society or public says, we also want to brief you on what we have found on 1, 2, and 3. That's my technical challenge. But I don't think from where I'm sitting as a portfolio committee will run away from people sharing information with us. But I fear a situation that we have tried to manage and deal with the issue, as far as I know, in those meetings. Whether this now is not standardizing a portfolio committee of parliament having regular quarterly meetings with one specific organ of civil society, and what message or implications it will have. And won't we end up being a committee that now attends to requests for presentations by every civil society? And I'm just saying this thing with extreme caution, that what criteria and on what basis will we do that? And how do we see or fit that into because if, for instance, the AG makes an opinion, that is a statutory body that is being made to do regular assessment and interaction. But the AG, by the way, comes in only twice in terms of our interaction with them. It will be when we are going to do the budgets, and then it will come back when we do a review of the budget or an assessment of the budget outcomes. But I need your help on this one. I find it very difficult, but I don't want to sound like we are opposed or against listening to other voices that might be critical. I thought with that meeting, most of those issues have been outlined and agreed on what then we're gonna interact going forward. I want to get someone who can help me. I see Honorable Matogwe. Is there any other hand? Honorable Mashal? Yes. Okay. Honorable Matogwe.
Thank you, Chair. I was going to actually request that for this item or this correspondence, that can the portfolio committee request a written report that we can process as members of parliament in our own time. I do not think that each and every report that is produced out there really warrants a face-to-face or warrants a meeting for that matter. So looking at what is the content of the report, it might assist us, but I do not think that it is necessary for us to process that in a meeting. If they can just give us a written report and then we'll use it at our own time. Thanks, Chair.
Okay. Honorable Mashal.
Chair, I want to align myself with Honorable Matogwe, precisely because we just dealt with a report that they had produced to us. And if there are urgent and important issues that they have produced now that are different or they feel are urgent to the committee, they can make a submission in that regard to say, for your attention, for your urgent attention are these issues that probably may need to be seen by the committee. We sit in a quarterly basis and agree on the program of this committee. It can't be that every time that when somebody produces a report, we have to slot them in every time. And I'm not saying this because it is one section of the civil society. All civil societies, we are here to can listen to them and schedule meetings with them. But this one, we just had a meeting with them and they presented the report. If there are other urgent findings that they may have produced now, let it be in writing and be sent to members, and we will see out of those findings that they think are urgent, and they must highlight what is it that they want us to see that is different to what they had produced, and we'll take it from there. Thank you.
Okay, thank you, Honorable Mahlaule and Honorable Mato. I can confirm that there is the report, but let me not make an opinion. I think what members are saying is that let's then revert back and say, look, we just had this meeting and we still appreciate, we need to process, but unfortunately, we've already scheduled the program, which is fully packed. In fact, it's not even accommodating certain things. Then subsequent to that, can we then agree that you submit to us those areas that you feel that they are so important and urgent, and then the committee on its own time, it will be able to look at those issues and then and be free also. I think we must say, Honorable Mahlaule, that in as much as they can highlight, if members feel that based on that report themselves, there are certain things that we need to tighten up to make the committee to be as effective and as productive as possible, let that be used also as a point of reference. Okay, if we agree, can we go to the issue of the, I'm not sure how can we agree that we will take this matter, honorable members, and include it, because we have dealt with the Welcome report. If we get the report itself, let's deal with it when we do the consolidation of the joint committee program, because that process now, we have dealt with it. It has been exhausted. We're in Welcome. Then we will include and factor it in when we deal with the joint committee report, and then we will then revert back to the writer on the issue that is being raised, if it is unique. Can we agree on that?
Agreed, House Chair. Chairperson, sorry.
Don't promote me.
Sorry, Chairperson.
Okay, the issue of the ESCOM board, can I brief members that the meeting is scheduled tomorrow from 10 o'clock up until 2, but it can or may go beyond to 2 o'clock. Obviously, the House convenes at 3 o'clock. Thank you, Honorable Mahlaule and Honorable Mailem, for your advices. Cost implication and other related matters, including the traveling challenges that we could have. We have engaged with with public enterprise, and we agreed that then let's try and finalize this process in the manner that you had suggested. Is there any other comment on this, honorable members? Okay, in the absence of that, you want to deal with the minutes, Ari?
Correct, Chair. Correct, Chair. There's about 5 sets of minutes, Chair. So we need to process it. There is time, Chair.
Yes, you can continue. I'm saying that if there's a disturbance, I might go on the road because I need to catch my flight to Cape Town. Continue, Ari.
My apologies, Chair. Now I need to open it, each one individually, Chair. So this is the Friday 23rd, Chair, last term's meeting.
Yeah, okay. It's the briefing by SGSA. Yes.
These are the responses by the department on those presentations, I Chair.
Okay. Okay, is there any move of the minutes? Any mover?
Chair, I move for the adoption of the minutes.
Okay, any seconder?
I second, Chair.
Okay, matters arising? I think the matters arising was on resolution 7, Ari. We need to do a follow-up so that, but remember we said, was it today, 1st of November or end of November? End of November, oh, okay.
End of November, Chair.
Okay. No, we're still on time. Okay, next set of minutes.
11 October, Chair, annual reports.
Yes. Okay, is there any mover of the minutes of the 11th November, October, August? You can just speak.
I move, Chair. Was I there?
You must check whether you were not load shedded.
You must check if I was not load shedded.
Yes. And then we'll remind you that you were load shedded. Okay, any seconder?
I second, Chair.
Thank you, Honorable. Any matters arising, but it's triple R's. Okay. In the absence of objection or matters arising, can we then look at the next set of minutes, Ari?
Just hold on, Chair. Let me open it quickly. Continuation of the annual report briefing, Chair. 13 October.
Sorry again, I'm talking to myself. They shouldn't be giving us any problems because it's only the briefings.
Correct, Chair.
Any mover? Any mover? Eh?
I move.
Chair.
Move for the second, Malinga. Next set, Ari.
Tuesday, 18 October, tabling of the first draft, BRRR, tabling of the oversight visit, and discussions on the oversight visit to Kuburg.
Let's go down. Okay, is there any mover of those minutes?
Yeah, I do move.
Move, Honorable Valmaran, seconder.
I second, Chair.
Thank you very much. Last set of minutes. Is to Khano. That is what is between you and going home.
Thursday, 20 October, Chair. Consideration and adoption of the BRRR, consideration and adoption of oversight visit. What is this? Update on the Kuburg nuclear power plant, yeah.
Any mover? I've seen the minutes, man. Any mover?
Okay, was I there? Hey, answers, Pelan load shedded.
Honorable Malinga is moving. Any seconder?
Seconded, Chair.
On that note, is there any other item, Ari, I forgot?
No, Chair, just to indicate a reminder of the meeting tomorrow, the meeting physically at Parliament, Committee Room 1 and 2, 90 Plain Street, from 10 o'clock till 2 o'clock, and as you've indicated, if need be, just before the sits at 3. And then we also have another meeting scheduled for this coming Friday, virtual meeting, Chair. Discussions on the upstream petroleum resources development law. That's it, Chair.
Thank you very much. Yes.
Yes, it's Langa.
Yes, Honorable Langa.
Yes, Chair. Just two things for clarity, and greetings, everyone. I wanted to check one, if is there any arrangement for transport tomorrow, and two, and this is just for clarity purposes, Chair. I would like to be schooled because I've heard the minister a number of times when he's greeting, and he recognizes everyone, including the whip of the committee. So for me, it was for the first time in this committee, because I've been to other committees as well, you know, to find out that there is should I call it, I don't want to call it a position, but a whip for the committee, because my understanding is otherwise. So today I did not want to disrupt the minister from an uninformed perspective. So maybe if we can clarify that for me. Thank you, Chair.
No, I don't know. I don't want to enter and speak on behalf of the minister. There is no whip of the committee. There is a whip of parties. But if you notice, that word is used interchangeable, even in the House. Sometimes the whip of the majority party is called the chief whip, when in essence it's supposed to be the chief whip of the majority party. So the word is sometimes is used interchangeable. I'm not sure whether it's an issue that it can be taken up as something that is unnecessary or that is necessary. That's why even the speaker doesn't bother if you say the chief whip. But most definitely from the other parties, they will talk about the chief whip of the majority party. So that is the answer I can give. We can't say that person is out of order in doing so. Neither can we say that then automatically imposes a new position in the portfolio committee. And that is why we never make it an issue for me from where I'm sitting. But we can get guidance. We can check whether when a person made that statement, it is a statement that is being made to be fundamentally altering. That's why, from a committee point of view, we have never, because that issue only goes with whether from a committee there is a recognition of that. That's why when Honorable Myleb, in one of our meetings, raised the issue, it was because it was raised by a member of the committee. You see, it was made by a member of the committee. So on those grounds, then there's nothing we could do. We had to then entertain that matter. That's all I can say for now. I don't know, is there, I'm trying to answer. With regards to transport, maybe then the staff can help us on that one.
No, angiphendulekanga, Chair, but ngizoyiyeka for now because istance sakho ngicabanga ukuthi ngiyasithola as well, but still I'm not happy.
The answer is simple. There is no whip of a committee. That's the answer.
Oh.
Two, if, for instance, you stand up and say the whip of the committee, and you are a member of this committee, it is correct, then you must be corrected. But I said then the word sometimes, that statement, that recognition sometimes is used interchangeably, even in the House. If I want to be upfront, you will get a member of the ANC saying chief whip, you see, of the House. But the reality is that you don't have a chief whip of the House. You've got a chief whip of the majority party in that arrangement. So, so it is not an issue. It is an issue when me as a chair or a member of the committee, even sometimes even if that's not the case, that's how I understand it. If me as a chair, I recognize a whip of the committee as a chair, then I'm wrong as a person who's presiding over the meeting because there is no whip of the committee. That's the point I was trying to explain. Yeah? Don't make my meeting. Can you answer the issue of the transport, please?
Yes, the transport will be arranged for members if there are no buses.
No, there are no buses. Buses were arranged for 8 o'clock for, if I'm not wrong, honorable members, I'm sure some received the messages. The buses were arranged for the NCOP only for today, and NCOP cancelled its meeting, if I'm not mistaken, for today. So there will be no buses at 8. To work on that, then if they say there are buses, let it be rejected by those who are organizing transport. Can we release then, honorable members? If there is no other item, Bablan.
Can you stay behind, Chair?
Yes, Chairperson. No, I think I got your response. I did not want to, further engage you because but somewhere along the line as well, you
got lost.
I got lost, So, but it's fine because when you spoke of you recognizing the chief whip and saying that will not be right, but it is your own meeting whereby you let the minister recognize the chief, the whip of the committee, when you know very well, when you're aware, we do not have such within the committees. Whether
No.
or not, but if in a position, we cannot allow someone to recognize what is not there, because then we are having positions that are imposed to us, So,
no, certainly.
Yes.
Let me plead with you. I said that word, even in the House, is getting used. I even became specific by party that they will use the word chief whip of the House interchangeable in the House. But the truth of the matter is that you don't have a chief whip of the House, unlike in the NCOP. That's my understanding. So I've never heard the speaker or the presiding House chair saying when a member says, can the chief whip do 1, 2, 3, or recognize the chief whip, and then say you are out of order. That is the point I was saying. I was saying that it would have been wrong for me to recognize that as if it exists when it doesn't. I did not recognize what the minister was saying as if it exists. But I didn't even have to comment on it because it doesn't exist. There's nothing that says that you are out of order when a person makes that statement. I will have to go and check then. I don't want to introduce my own rules, but I've never heard in the House people objecting to that. But while learning, I will go and check then. Okay, honorable members, if there is no other matter, can we then R says he wants us to remain behind as usual.
Only you, Chair. Only you, Chair.
Members in the transport.
Can we please have times communicated for the transport tomorrow, please?
ikhona ibhasi bathi ngathi ayikho ibhasi
Makubalo.
No, we will come back to you. You are correct, and you will have to get the information before even the house sitting at before 2 o'clock today, or by 2 o'clock today when you are in the house. That's my guarantee, honorable members. Can we leave it at that? Can we go?
No, thanks, Chair.
Okay.
Voli, thank you.
Thanks. See you.
See you.
Recording stopped.
Hey, where does we see?
Chair?
Ari, yeah, does we see?
Some of us are busy. No?
Like me, I told you I'm chasing the flight now.
Ari, let's shoot.
Huh?
Straight to the point.
Let's shoot quickly.
Everybody out that's supposed